As we are living in a very modern world, so in today's world, understanding the concept of contract is very much important, as it is very much relevant in our day-to-day life. For example, if you want to sell your property or buy any new property or any kind of a business deals or any kind of agreement, you need to understand the basic criteria of a contract, like how a contract is made and who are the parties who can enter into a contract, like who are eligible for entering into a contract. So the basic understandings of contract or the basic principles of contract have been discussed in Indian Contract Act 1872, where the definition of contract have been discussed and all the basic essential elements for making a contract have been discussed, and who are the parties who can enter into a contract have been discussed, and what will be the contracts that will be valid in front of the law also have been discussed. So in this video I'll be discussing about the basic principles of contract, like what will be the definition and what are the essential features of a contract, the nature of a contract, and what are the types of the contract. So Indian Contract Act have defined in a contract as an agreement which are enforceable by law. So it is a very simple definition which have been defined by Indian Contract Act, like it is an agreement which becomes enforceable, that becomes a law. So we have to understand that what is an agreement and what is meant by enforceable by law. So agreement is something where two parties are agreeing upon a something, or two parties having a mutual mindset entering into a contract. So how an agreement is made? For making an agreement, first one party have to make an offer, and that offer must be accepted by another party. So for making an agreement, there must be one person who must be making the offer, and there must be another person who must be accepting that offer. And this offer and acceptance, when comes together, this makes an agreement. And this makes a promise. Sorry, when this offer and acceptance comes together, this makes a promise. And when one or more than one promises comes together, this makes an agreement. So this is a basic formula of agreement, where two parties are agreeing upon something. One party is making the offer and another party is accepting the offer. These offer and acceptance comes together and makes a promise, and one or set of promises becomes together, makes an agreement. So this was the concept of agreement. Now we have to understand what is meant by enforceable by law. Basically, enforceable by law means something which can be brought in front of the court or in front of the law when the rights of the parties are violated. For example, fundamental rights. The fundamental rights guaranteed to us, the citizens, if the fundamental rights are violated anyhow by the government or any other government institutions, so we have the right to seek remedy in front of the court or in front of the law. So similarly, contract is an agreement. When it becomes enforceable by law, it becomes a contract. That means contracts are also can be enforced in front of the court or in the eyes of the law, where the rights of the parties, if they are violated, the parties can have ask for remedy to the court. That means contracts are also can be enforced in front of the court or in the eyes of the law, where the rights of the parties, if they are violated, the parties can have ask for remedy to the court, and the court will give them the remedies if their rights are violated. If the parties into the contract, one of them breaches their duty, and due to that breach another party's rights are getting violated, the court will give remedy or give compensation to the another party, where the parties will not have to face any kind of loss. So this was the concept of enforceable by law, where a contract can be enforced in front of the law. So this was a simple definition of a contract given by Indian Contract Act. So now I will be discussing about the essential elements of a contract, like what are the essential elements which makes an agreement enforceable in front of the law and which makes a contract. So the first essential element of an agreement to becoming a contract is offer and acceptance. So there must be an offer made by one party, and there must be an acceptance made by another party. Like one person must be making an offer and the another person must be accepting the offer. For example, if one person wants to sell his property to another person, that person must be making an offer to the another person who wants to buy the property, and if the offer and acceptance becomes together, that is becoming an agreement. So this was the first essential element, offer and acceptance. There must be an offer, there must be an acceptance. Second essential element is intention to create legal relationship. When two persons are entering into a contract or they are making an agreement, there must be an intention in between the parties that they are entering for a legal relationship. Any casual kind of relationship, if they want to go for a movie together, if they want to go for a party together, if they want to go for a park together, that will not create a legal relationship. So there must be an intention in between the parties who are entering into the contract or who are entering into the agreement, that they are entering into a legal relationship. This intention to create legal relationship is very much important in making any kind of contract or in formation of a contract. Third essential element is lawful consideration. Consideration is something which must be given by one party to another party while making the contract. Like consideration is something which can be said as something in return. So when the parties are entering into a contract, both parties must be getting something in return. For example, I am selling my property to another person. So if I am giving my property, or I am giving the possession of my property or the ownership of my property to that person who buys my property will be consideration for that person. And if that person, when the person will be giving money to me for buying my property, that money will be consideration for me. So this is the concept of consideration, where the parties must be receiving something in return, that is the consideration. So for entering into a contract, both parties must be receiving a lawful consideration, which is very much important. If any consideration is not lawful, is not legal or not lawful or invalid in front of the law, that contract is not a valid contract, or that agreement will not be enforceable by. Next important essential element is capacity of the parties. Means the parties who are entering into the contract, those parties shall have certain capacities, or they must possess some essential criteria in front of the law. What are the criteria? First criteria is that the person must be 18 years of old. Means the person must be a major person. If the person is not a major person, that person cannot enter into a contract. Second one is the person must be sound mind. That means the person's mind shall be working properly, and that person is eligible for giving any kind of proper or valid consent. And the third one is that person shall not have any kind of legal disability. That means the person shall not have any restrictions made by the law. So these are the criteria or capacities which a person must possess to enter into a contract. Next one is free consent. That means the person who are entering into a contract, whenever they are giving the consent for making the contract or entering into a contract, that consent must be given free and voluntarily. That consent must not be obtained by any kind of compulsion or any kind of fear. Okay, and there are 5 essential elements which if the essential elements are present there, then the consent is not considered to be a free consent. Those elements are coercion, undue influence, fraud, misrepresentation and mistake. Okay, so the next essential element for making a lawful contract is lawful object. So lawful object is something where with which object you are entering into a contract. The parties entering into the contract, they must have certain lawful object. Like why they are entering into a contract. If they are entering into a contract for any kind of business agreement, business deal, for buying or selling property, for any commercial object, all those must be a lawful object. If the object of making a contract is not lawful, that contract cannot be said as a legal or a valid contract. So the agreement will not be enforced in front of the law if it is not made with a lawful object. Now I will be discussing about the concept of free consent in contract. So concept of free consent means when the parties are giving their consent voluntarily, and when it is not caused by any kind of compulsion or not any force. So a consent is said to be free when it is not caused by 5 elements. What are those elements? Those elements are coercion, undue influence, fraud, misrepresentation and mistake. So now let's understand what are the elements which does not make a consent as a free consent. First one is coercion. Coercion means when one person puts any person into a fear or any compulsion, and by that fear or compulsion the another person gives his consent to enter into the contract, that is called as coercion. Means when any person is not giving the consent voluntarily, that person is giving his consent in any kind of force or compulsion. So that force or compulsion must be present there in coercion. So if a consent is given for the reason of coercion, that consent is not considered to be as a free consent. Next one is undue influence. Undue influence means when one of the parties from the two parties of a contract is in a superior position, and when another party is in an inferior position, and the party in the superior position take advantage of his position and makes a pressure into the parties who are in the inferior position, and gives a pressure to that person, and that person being in an inferior position have to give consent to entering into a contract. That is the example of undue influence. Means where any person takes advantage of his superior position and makes a compulsion to the person in the inferior position, and due to the position that person is liable, or that person in compulsion gives his consent to enter into the contract, that is undue influence. Next one is fraud. Fraud means when one person with voluntary intention deceiving the another person. When one person deceives another person voluntarily, that is called as fraud. Next one is misrepresentation. Misrepresentation means when one of the parties into the contract intentionally does not state about the true facts of the contract, or hides any fact of the contract, or misrepresents the contract in front of the another party. And if another party in a false belief gives his consent to the contract or to the agreement, then it is called as misrepresentation. Here the concept consent given by the another person will also not be treated as a free consent. The last one is mistake. Mistake means where either one party or both the parties are giving their consent into the contract or into the agreement by reason of any mistake. That must be a mistake of law, mistake of fact. The persons entering into the contract will not be considered as a valid contract because the consent was given under mistake. Lastly, we have to understand about the difference between an agreement and a contract. So basically an agreement is something which is not enforceable by law, which cannot be enforced by law. And when an agreement fulfills the essential elements of a contract and all the essential elements have been fulfilled or have been complied, then only an agreement becomes a contract. So there is a term which says that all contracts are agreement, but all agreement are not contract. So when any agreement that fulfills all the essential conditions, all the essential criteria, it have offer and acceptance, it have a valid, it have a free consent, it have the parties, it have lawful consideration, the parties are free, the parties are major, the parties have sound mind, all those conditions are fulfilled, then agreement is becoming a contract. And when a agreement becomes a contract, then only it is enforceable in front of the eyes of the law, then only the parties will have the rights and parties will get compensation. And but if it is an agreement and if it does not fulfill all the essential criteria of a contract, it cannot be enforced in front of the law and the parties cannot claim any kind of right or any kind of compensation in front of the eyes of the law. So this was the concept of contract, which was very much important to understand in today's world, that because the contract is very very important in our modern world, because we need to understand the concepts of contract in our day-to-day life, because contract is very much relevant in today's world, and we have to understand what are the basic criteria of a contract, because we have to go into a contract very frequently, and if we do not understand the concept of a contract, we will be deceived by another person. So it is very much important to understand all the essentials of a contract and how a contract is made.